extreme disappointment with you. You've now picked up a new case. Is it on docket today or no?
It is, Judge. We placed it on after we spoke.
Thank you. Mr. Foster, you now stand charged with the offense of assault. You were facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. For some reason, I don't see it.
Your Honor, it's understood.
Well, Judge.
Tristan Smith. I'm sorry. I called you Foster. I meant Smith.
Can you, ADI was a 2B, so this is a walkthrough on the new case, the new charge. The previous one, which was the AFM, because he has 2 open misdemeanors right now.
Right. So he initially had the open assault of a family member.
Yes.
As of December 19th, he's now picked up a new assault.
Yes.
All right. Let's do probable cause
On the new assault.
on the new one.
Yes, Judge. On October 29th, 2024, an officer was assigned to investigate an assault that occurred on the 18th of October at a residence in Harris County, Texas. The officer reviewed video footage of the assault that showed the first complainant and the defendant engage each other in a physical fight until another female assisted the defendant by punching the complainant and grabbing the complainant by her hair. The female swung the first complainant to the ground by her hair, causing pieces of her hair to be ripped off while the defendant punched the first complainant multiple times in the face. As the first complainant was on the ground, the defendant stomped once on the back of the first complainant's head, and the officer observed the first complainant with injuries based on photos. The first complainant told officers that on the day of the offense, the defendant told her that he was going to assault her once she exited her vehicle, and a friend of hers that was inside the vehicle recorded the fight. The defendant and the first complainant used to be friends, and the defendant used to live with the first complainant at her residence until the defendant was kicked out.
Judge, if I can, just utilizing the state's information that they provided, I didn't hear the prosecutor read this part, but at some point the officer interviewed the complaining witness in the new assault. Based on what she told him is that she had heard that Mr. Smith was going to attack her. And if you just read in the DIMS, she exited her vehicle to engage in a physical fight with Mr. Smith to defend herself from him. When I talked to Tristan about this last week, he told me all about it. He said, I remember this because it is a 2B. He hadn't heard nothing, any follow-up on it. This young lady got out of her car and attacked him as he was walking down the street. It says it right here. MB exited her vehicle to engage in a physical fight with Mr. Smith to defend herself from him. She's in a car where she could have easily seen him and kept driving. No, she got out of her car and attacked him exactly like he said. And while he was defending himself against her, another individual, another female came to assist him in this fight because he was attacked and blindsided. This is exactly what the complaining witness in this case told the police happened, except she said that, well, I heard that he was going to attack me, so I jumped out my car and attacked him first. That's not an assault.
I don't know. All I know is that the facts are pretty egregious. And I mean, he could have taken off, didn't have to sit there and didn't have to engage. He could have, you're on bond for a criminal case. So stop. I'm not asking you to say anything. You, in the correct mindset, I have an open assault. It's probably a pretty good idea for me to go away and not do anything here.
And if he had that time to reflect in that instance, then perhaps he should have done that. But he's walking down the street and this girl jumps out the car to engage him in a physical fight like she told police that she did to defend herself from him. He doesn't have time to sit and reflect, I got a case and all that.
He could have run away. He could have gone. He could do something else. I don't know.
Being attacked, Judge, you got to do something.
Look, I get that there's always two sides to the story. But I'm going to find there's probable cause now.
I understand.
If you develop something later, if you see something on video, if you show something that she's the initial aggressor, come back and we can talk.
She said it. She told the officer.
I don't know that for sure. It just,
Let's say in self-defense.
Yeah, we have in self-defense, and then we have furthermore that once the female was assisting the defendant, that the defendant continued to assault the complainant, even stomping the complainant on the head.
You got to stop her if she's attacking him.
Well, Judge, she was down on the ground. The complainant was down on the ground and the defendant stomped on her face.
I'm finding that there's probable cause. You picked up a new case.
And we'll deal with that, Judge. But the biggest issue, of course, is the fact that he did pick up a new case, albeit he didn't ask for it. I mean, he's walking down the street. And his situation being one that's extraordinary, one that I haven't seen much this year, dealing with indigent defendants, being of his age, which is a high school student, as we've talked about before, pending graduation with an acceptance to a great school. This is a very tenuous time for him. You've already ordered him to be drug tested before and all of that. So we're working through those things. The last thing that, and I know we have to consider the complainant witness in the community and all of that. I understand that. But I'm advocating for Mr. Smith.
I get it.
Mr. Smith has a final on Monday that he must take. If he does not take this final, and he's again in high school, then he may not graduate. If he doesn't graduate, then we can kiss Baylor goodbye. It's not likely to happen for him in light of all of the challenges that he's dealing with. He doesn't have his mother to help him. His grandmother, we know she's a complaining witness. He can't even go around the house. He doesn't have any help right now. He's living with a friend and walked here from Atascocita this morning, which took him 9 hours. I mean, this situation it's extremely difficult, Judge. So my ask is that we do something, and it could be amend bond conditions, but to keep him on bond so that he can take his test, do what he needs to do to finish school, and hopefully we can resolve these issues. I've looked at the evidence that the state has submitted for the new case. There's clearly something happened, clearly. I mean, and I would see the evidence shows that. But if he's walking down the street and this girl, per her own admission, jumps out her car to engage into a physical altercation with him to defend herself, that doesn't make sense. And that's not really fair to him. Someone that's on bond, and everybody knows he's on bond because she said, I knew him. We used to be friends.
He could have walked or run away, gone to a store, called the police. There were a multitude of other options you could have done. You know what's at stake here, yet you pick up another case where you allegedly stomp on someone's head and you want me to let you go. I understand that you have school. I don't know that you have a final on Monday. Am I supposed to take your word for it? No. All I know is that you are a danger to my community. You have one assault. You have had violations on bond while you're on that assault, and now you've picked up another assault. You are a danger to my community. And there's only one thing that I need to do, and that's to put you in jail because you refuse to comply with bond conditions. And I've given you over and over. I appreciate your tenacity, and I love that you're defending zealously, but I can't let him go. It would be enabling this behavior and telling him it's okay for you to do what you're doing. And it's not. It's not okay to sit there and stomp on someone's head.
And Judge, we anticipated that possibility. I'd ask in the alternative that you consider a very low bond, as my client has approximately $100 to his name, being a child, in my mind, a person that hasn't even graduated from high school.
State of Texas, what do you think?
Judge, we would be opposed to that. I mean, given the egregiousness of these facts, we believe the defendant is a...
I won't do the normal. What I normally do is I set bonds at $5,001 when you pick up a new case. I'm willing to go down. I'm not going to give him a $100 bond because that's what we do on new cases.
I'd ask for...
I think that's a little...
So we're going to revoke the previous bond. That was a personal
And
bond.
we'll only touch the old case.
And so we'd ask that, well, I didn't anticipate that you set a personal bond on the new case. So I guess my request would be 2 $500 bonds.
Oh.
I mean, we're talking about a misdemeanor assault between children, not a...
Well, I don't know that. I mean, you're putting in stuff that I have no
The
idea
state
about.
alleged a misdemeanor assault. They didn't allege an aggravated assault, which they could have, and they did not. They alleged a misdemeanor
Doesn't make
assault.
me feel better.
I mean, the state says, alleges that there's all this injury. We can see what the injuries were. You see the complainant witness in the picture. She's smiling.
Did you go to
she's
the
talking
hospital?
To the police. No, she didn't go to the hospital, Judge.
But just going off the DMs, we have her hair being ripped out and being stomped. So,
And to your question, not hospitalized, Judge.
So here's what I'll do.
Judge, just if I may add, even in the first AFM, Judge, the complainant has gone back to the home at least once, to my knowledge, based on my communications with the complainants on that case. The defendant has gone back to the grandmother's homes contrary to the bond conditions and the no contact orders. In that case, he's repeatedly, time and time again, violated his bond conditions. And now so we would be opposed to anything less than $1,000.
Yeah, I know. So what I was going to, his bond on the first assault it's $1,500. I'll do 2501 on that. Okay, I'll only raise it at $1,000. On the new case, what do you think? Should we give him a PR bond?
Judge,
No, Judge.
we'd be opposed based on the nature of the allegations where he stomped on someone's head, pulled her hair, and in addition to that being picked up just a month after the previous AFM.
And charged with a misdemeanor. I mean, if the state felt so vigorously about this case, then they would have filed it in district court. I mean, this is a misdemeanor assault between.
I think there's no way this would have been gone upstairs.
I agree, and which is why I think a personal bond could be adequate in light of the fact that he would be given a surety bond on his previous case. He doesn't have much of anything. If anything, that keeps him in jail until we get to trial, because that would be a case that we would set.
All right, Mr. Brooker, I'll set the new one. I'll set it at $500.
Thank you, Judge.
I hope you get it. You're going in today, but I hope you get it. I mean, we're not going to stand for this. You got to pay the piper. And I don't know if it's dealing with the school now will get you to wake up and realize that you can't do what you're doing, but that's it. I've literally bent over backwards not to put you in jail, Mr. Smith. Literally bent over backwards. How many chances have we, Goes with you. Okay, Mr. Smith, good luck. You've picked up a new case, Ms. Simmons. Irvin, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with the offense of criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine.
Yes, Judge. The officer was dispatched to a club in Harris County, Texas in response to a disturbance. The complainant, an employee of the club, told officers that she had asked the defendant to leave and the defendant refused. The defendant had been trespassed by another officer the day prior, and the complainant stated the defendant continues to return to the location. During the incident, when the complainant told the defendant to leave, the defendant stated, "Leave me alone or I'll hit you in the head." The defendant told officers that everyone at the location was trespassing and that she should have been given a pink paper in order to be trespassed.
Okay, ma'am, I'm going to find that there's probable cause to go forward with the case. You've picked up a new case. The only thing I asked you to do was not pick up a new case, and now you've done it. So what happens now? Corey?
Judge, I'm going to ask for you to allow her to remain on bond. The state hasn't filed, if that's what you're getting at. The state hasn't filed a motion to revoke bond. I'm not prepared for it. If they have, ask for time for a hearing to be set. So we can, have a hearing based on evidence. She hasn't violated the bond conditions, from the previous case as far as they relate to going to the housing authority.
She has, though. One of the conditions is behave yourself, give no facts or rise to probable cause that you violate any new laws. She's now picked up a new case.
Right. What I'm saying is related to your very specific orders about her not to go back to the address where her apartment was or the Houston Housing Authority address. She's complied with those terms.
But if I let her go now, that's enabling this behavior and telling her it's okay.
Well, Judge, I think it would be punitive if you put her in jail as opposed. Well, that's not the purpose of bond, right? It's community safety and the community.
She's threatening people allegedly there to beat them in the head. She won't leave.
That's hearsay. Let me do the talking.
Take you into custody, ma'am.
Judge, that's hearsay. I think we're entitled to a hearing.
Yes, I'll give you a hearing. Sure. Whatever you want.
My arm is broke.
I don't know how else to, she's going to do whatever she wants to do. How am I supposed to handle it?
I'm not a threat to the community, so I'm not understanding, and as I said, that is hearsay. Is there any way, can you subpoena the cameras? Because I didn't threaten anybody, and there is also multiple witnesses that was there as well.
Sure. So that's my job. That's not the judge's job, and I'll do that just like I've done for the previous case.
So,
Judge, can we allow her to remain on bond until we have an actual hearing following the rules?
I haven't been around
following the rules of evidence for bond revocations.
Here's what we'll do, Corey. What I'm going to do is I'm sending you for a drug and alcohol test now. If you fail to take the test, if you fail to do what you're supposed to do, I am going to revoke your bond and put you in jail. I'm now putting a GPS monitor on you and I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Okay, 1 second. I'm homeless because they have refused to let me back into my apartment.
I'm not going to talk to you. This is not a negotiation.
No, I'm
It's
not.
either you follow the conditions of bond or I'm going to revoke it and put you in jail.
Okay.
This is better
So
than being in
whatever you
jail,
want.
unless you want to be in jail.
Your lawyer's asking me not to put you in jail now.
Well, how long
You
will I be in
picked
jail?
the case.
Until November the 22nd.
No, I'm sending you for a drug and alcohol test now. We are going to reset this case until Monday.
That's the-
You were to come back Monday so we can address it. In the
I
interim,
did consume alcohol. Not anytime soon. So that's fine.
I want you to listen.
Anytime.
I'm going to put a GPS monitor on you and I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Where is my curfew supposed to be from is the question. Because if I'm currently homeless and I am sleeping on the city streets, residing, because they refuse to let me back into my apartment, where
Know what you're doing.
is that supposed to be at?
That's what these conditions I'm giving you, ma'am.
It'll be within an exclusion zone. We do GPS within exclusion zones. since we
Sure.
Have a permanent.
Oh, okay.
Address then?
But I don't. I'm ordering you not to consume alcohol or illegal drugs. And I'm going to randomly test you, but I'm saying you now for a test, you're to come back Monday. Do you understand?
That's fine.
Okay. I'm giving you a monitor on your ankle. I don't want you going to any clubs, bars, or anything of this nature. Do you understand?
That's fine.
Thank you, Judge.
See you Monday.
Yes, sir.
And I'm sending her now for a test. I want to know what, if anything,
Where do I go to take this test?
she'll tell you.
Curfew's 9 p.m. to 6 a.m. Okay, so if she's homeless, we need a home base for the GPS to observe people.
That's what I was trying to say.
She's got to live in somewhere. Got to be
I
living.
don't have friends or family or nothing, so that's what I'm saying.
You put your head somewhere down at night.
Yeah, on the city streets.
We'll get an address for it. Thank you, Judge. It's better than jail.
Yeah, it's not gonna be exaggerated either.
With racing on a highway, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 27, 2024, the officer was assigned to a traffic crimes task force and followed a group of 40 to 50 racers from 2400 block of Turning Basin to the 610 loop. The officer,
Say 40 to 50 racers.
yes, Judge. And the officer observed the defendant and co-defendant's motor vehicles in lane 1 and 2 slow down to approximately 30 miles per hour. And both vehicles took off side by side, trying to outpace each other at approximately 100 miles per hour. A traffic stop was conducted and the officer made contact with the driver, the defendant, and he was the sole occupant of the vehicle.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has a valid?
Not eligible, Your Honor.
You were not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive, and I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing every time you drive. It's an offense in and of itself, punishable by up to 6 months of jail and a $500 fine. Do you understand? Do not drive. Whenever you fill out the affidavit promising us you're not going to drive, we will get you to Victoria, sign a reset, and we're going to get you out of here. When you come back, please have a lawyer. Ma'am, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford